record taking roll. So we have started recording. I appreciate the reminder. For those of you who were not in the first class period, we spent the first class reviewing the ICR, the syllabus for the course. If you have any questions about it, please email me and I will assist. Right, if anyone doesn't yet have their textbook, you can obtain a PDF of Chapter 1 from me by emailing me and letting me know that you need it. Somebody just came in. All I have to do is find them. There Remy is. Got it. Okay. Otherwise, okay, well, we will start with the beginning of the chapter. Anyone who has emailed me requesting access to the textbook should have received the PDF of the textbook. Is anybody missing a textbook who actually sent me a request? Great. Just trying to make sure I am keeping up with everything. Okay. Huh. Okay. Gabby, make sure that you spelled my name correctly. It's Silverberg. If you put Burg, it'll bounce because there's nobody in the system by that name. That would be the problem. At least it was easy. Sometimes the way email doesn't work is a lot more complicated, but happily, thank you, Jessica. I'm just putting you on the roll. That's not an uncommon problem, so I'm glad to be able to give you, to explain where that issue comes from. If you'll just send me the email, I will send it back as soon as I get out of class. I've put my phone on Do Not Disturb, and I've put emails on hold in order to that we're not disturbed during class, but I will get to it as soon as we get out. Perfect. Okay. Legal research is the investigation for information necessary to support legal decision making. In order to understand the process of legal research and the process you go through in order to investigate the information that will help you make legal decisions, you first need to understand the sources of law, which brings us to kind of an unusual quirk in the law, and that is that lots of different terms are used to mean multiple things. For example, the term sources of law can refer to the origins of the legal concepts or ideas, or the institutions that formulated the rules, that is, who wrote it, or where do you find it, that is, the published manifestations of the law. So when we talk about sources of law and we're wanting to know where did it come from, that is, where did the ideas originate, legal ideas and concepts have their origins in custom, tradition, principles of morality, and economic, political, philosophical, and religious thought. Occasionally, your legal research may extend to these areas where you're looking at historical or policy issues. Secondly, sources of law can refer to who actually created the law. That is, the governmental institutions which formulated the particular legal rules. In this country, that refers to the three branches of the federal government: the executive, the legislative, and judicial branches. The 50 autonomous state governments with their three branches of government. Here again, executive, legislative, and judicial. And the government of the District of Columbia. Each of these entities makes law. And you need to understand the types of information created by each of those branches. That is, that the legislative branch makes law through legislation. The executive branch makes law through executive orders and rules and regulations. And the judicial branch makes law through the issuance of case opinions that define, interpret, and apply the law created by the other branches of government. Finally, the term sources of law may refer to where do you actually locate the material. That is, what are the published manifestations of the law? The first thing you need to understand is that the term published used to mean printed. Today, published means disseminated for general use. That doesn't mean free dissemination, it just means dissemination. So, dissemination for general use can be in print, it can be a recording, it can be electronic, it can be a database, it can be an ebook. Published manifestations of the law include books, databases, microfilms, microforms, optical discs, CD-ROMs, DVDs, and any other type of media that may contain legal information. All of these are considered to be sources of law. So once we understand the sources of the law, the next thing we need to understand is the nature of legal authority. Here again, we have a term that has multiple definitions. Specifically, legal authority is any published source of law setting forth legal rules, legal doctrine, or legal reasoning that can be used as a basis for legal decisions. But the term authority itself refers to both the type of information and the degree of persuasiveness of that information. There are two types of legal authority. We have primary authorities and we have secondary authorities. Primary authorities are authorized statements of law by governmental institutions. These include case opinions and reports, that is, the written reports and written opinions of courts, state or federal. They include constitutions, legislation, the statutes, rules of court, the statutes, codes created by the legislature. They also include rules of court, the rules, regulations, opinions of administrative agencies, and executive orders. So primary authorities are authorized statements of law by the government. Secondary authorities are basically everything else. Statements about the law which are used to explain, interpret, develop, locate, or update those primary authorities. These include treatises, articles in law reviews or other scholarly journals, American Law Report annotations, restatements of law, loose leaf services, encyclopedias. All of these are essentially commentary on the law in one form or fashion or another, somebody explaining what the primary law says. Once you know the type of authority you're dealing with, then you need to figure out the extent to which a client, a court, will be persuaded by that information. And we have two different types or levels of persuasiveness. Different authorities have different levels of persuasiveness. This persuasiveness is an estimate of the power of the information to influence a legal decision. Certain authorities are what we call binding or mandatory authority. That is, a court or other decision-making body believes that the authority applies to the situation before it and must mandatorily be followed. Only primary authority may be binding or mandatory. So secondary authorities are never binding or mandatory, but just because something is a primary authority doesn't mean it is automatically binding. Whether or not it is binding will depend upon the particular circumstances. For example, a case opinion from the Texas Supreme Court is binding on all Texas state courts, but it is not binding authority on federal courts, nor is it binding authority on a court of another state. It might be persuasive. Persuasive authority is authority where a decision maker can, if persuaded, choose to follow the authority. In many cases, primary authority is merely persuasive because of the source of that authority versus the jurisdiction that you are in. So different authorities will have different levels of whether they're binding or persuasive, and the degree to which they are persuasive will depend on the jurisdiction you're in. Secondary authorities are always only persuasive, but secondary authorities are not the only authorities that can be persuasive. Sometimes primary authority is also just persuasive. It depends upon the jurisdiction and the circumstances of the case that you're dealing with. And you'll learn what's persuasive and what's binding as we go along. To some extent, especially when you are dealing with case law, it has a lot to do with jurisdiction and where it comes from and who you report to, as we'll talk about in just a moment. The vast majority of the law in this country comes to us through what's called the common law tradition. The common law was a body of law originated and developed in England, and it spread to those countries which England settled or controlled. Historically, the common law was considered to be unwritten law as distinguished from written or statutory law. Under the common law theory, there is no presumption that all law is codified in the statutes or codes. This is contrasted with the civil law tradition that comes to us from Roman law. While the common law tradition is in effect in England, Great Britain, and all of those areas where Great Britain settled. So in India and in Canada and in the United States, for the most part. And other areas where England or Great Britain took their form of law and justice, those are common law tradition jurisdictions. Continental Europe, Italy and France and Germany, Spain, are generally civil law jurisdictions. In the United States, the federal law is a common law system, and 49 of the 50 states also follow the common law tradition. What state is a civil law tradition state? Any guesses? Louisiana. That is correct. Louisiana was settled by the French, and prior to the Louisiana Purchase already had established law and established practices of law, and so state law in Louisiana follows the civil law tradition. It means if you choose to work in the state of Louisiana, I will highly recommend that you take a Louisiana law class before you try to work in that state, because the way things work in Louisiana is completely different than anywhere else in the United States. Under the civil law tradition, there is a presumption that there is a statute, that there is something in the code that covers every single legal question that might arise. Whereas in the common law tradition, the presumption is that while statutory law covers some material, a lot of things are decided based on tradition and the doctrine of following precedent. That is, the decision of a court not only decides that particular case, but sets a precedent under which future cases can be decided, and thus establishes specific rules of law. In order to understand our case law and the way in which the common law itself developed, you first need to have an understanding of the structure of the court system. On both federal and state levels, there are hierarchical judicial systems under which certain courts have jurisdiction or control over other courts. We have a hierarchy of courts, both on the federal side and on the state side, and that hierarchy creates levels within the courts. At the lowest level, we have trial courts. These are courts of original jurisdiction, that is, they hear original trials. You have documents prepared by the parties called pleadings and motions, which are filed before and during trial. These are courts that hear testimony, review facts, render judgments. They rarely file written opinions regarding their decisions, rather they issue written judgments. Even when a court does write an opinion, very few of those opinions are published, because decisions of trial courts are binding only on the parties and the court that issued that decision, because nobody else refers to that court. A decision made at the trial court level does not create a precedent. On the federal side, we call our trial courts U.S. district courts, and we have hundreds of them. Those courts make decisions about individual litigants and decide those individual cases. Occasionally, a federal trial court will issue an opinion, usually in a case where nobody's seen this question before, what we call a case of first impression. In that situation, it is likely that the court will issue a written opinion that may be published solely for the purpose of providing guidance to other trial court judges as to what they did. A trial court opinion is never binding. It is only ever persuasive. Its purpose is to give guidance to other judges suddenly seeing the same question who want to know how someone else may have covered the same material or how they may have decided the same question of law. On the state side in Texas, we have multiple levels of trial courts. At the lowest level, we have municipal courts and justice of the peace courts. In the middle, we have county courts, both constitutional county courts and statutory county courts. And the highest level of trial court in Texas is a Texas district court. What all three of these levels of courts have in common is that they are courts of original jurisdiction. That is, they hear original trials, disputes between parties who are suing for redress of a wrong or to obtain relief from the court based upon something they allege that the other party has done. Here again, trial courts in Texas issue decisions, but they do not issue opinions. And those decisions are binding solely upon the parties to that individual lawsuit. At the intermediate level, we have what we call intermediate appellate courts. On the federal side, these are the United States Courts of Appeals. On the state side, these are Texas Courts of Appeals. In each case, these courts have authority over a certain group of trial courts, generally based on a geographical area or jurisdiction. Appellate courts do not hear evidence or review factual matters other than that contained in a trial transcript. Appellate courts review claimed errors of law that are reflected in the record created by the lower court. Appellate courts issue written opinions, which opinions are sometimes published and available for review. Those written opinions form the basis of a precedent as to how you decide particular types of cases, and those opinions are binding, at least as to the courts which report to the Court of Appeals issuing the opinion. At the highest level, we have our state and federal courts of last resort. On the federal side, that is the U.S. Supreme Court. It is the highest appellate court in the jurisdiction that is the United States of America. The state Supreme Court, or the state highest court, because they have different names in different states, is the highest authority on the law of that individual state. When that highest court speaks, those opinions are binding on everyone and every court within their jurisdiction. So when the U.S. Supreme Court speaks, everybody listens. When you're in a given state, when the state highest court speaks, every court in that state, every state court in that state at whatever level must follow that opinion. It is binding and mandatory authority on all of the jurisdictions which report to the jurisdiction issuing that opinion. So on the federal side, you've got the three levels. You've got the U.S. District Courts, you have the U.S. Courts of Appeals, you have the U.S. Supreme Court. We have one Supreme Court. We have 13 U.S. Courts of Appeals, 12 geographic circuits, and the U.S. Court of Appeals for the Federal Circuit. And at the bottom, we have all of the U.S. district courts, which is usually one or more individual district court districts per state, and then multiple judges within each district court district in each state. Here in Texas, we have 4 U.S. district court districts, the northern, southern, eastern, and western districts, and geographically the lines are a little convoluted. So there are parts of the Eastern District of Texas that are west of the easternmost parts of the Western District. There are parts of the Northern District that are south of the northernmost parts of the Southern District. It's kind of an unusual mess. When we get there, there is actually a diagram of the federal court districts in your book. It is contained, let's find where it is. Courts. It's on page 60 of the textbook, and you can see the delineation of those spaces. We're not going to spend time on that today, but when we get to chapter 5, we will discuss that. So if you already have the textbook, you can look on page 60. If not, when you get your book, you can look at the diagram on page 60, and it'll give you a little bit of a sense of the delineation of the district court districts in Texas. At the intermediate level, we have the U.S. Courts of Appeals. The country is divided into 11 U.S. Court of Appeals districts that contain 3 or more states or territories, plus the District of Columbia Circuit, plus the U.S. Court of Appeals for the Federal Circuit. The U.S. Court of Appeals for the Federal Circuit hears appeals of specialized cases, patent and trademark issues, copyright issues, things of that nature that are specifically federal questions and deal with specific federal agencies. Although at trial they can be tried in any U.S. district court, on appeal they go to the U.S. Court of Appeals for the Federal Circuit to ensure that a court that is familiar with those areas actually hears the case. Texas is part of the U.S. Court of Appeals for the Fifth Circuit. The Fifth Circuit Court of Appeals includes Texas, Louisiana, and Mississippi. And as is common, the U.S. Court of Appeals will sit in a principal city within the jurisdiction. The Fifth Circuit Court of Appeals sits in the federal courthouse in New Orleans. On occasion, the court will hear cases somewhere else. When Hurricane Katrina hit New Orleans, the U.S. Court of Appeals moved their font up and moved the court and set up shop in the federal courthouse in Houston. As it turned out, that was not the best choice, in that the court had been up and running for about 10 days when Hurricane Rita hit. A lot of people forget that the same year we had Katrina, we had so many storms we got to R, and Rita hit Houston about 6 weeks after Katrina hit New Orleans. It made for an interesting time. We're lucky that Marco fizzled, otherwise we were about to have the unusual experience of seeing 2 tropical storms or hurricanes hit virtually the same location in the country at the same time. As my husband's been saying, who has mating hurricanes in August on your 2020 bingo card? As it turned out, it didn't happen. Marco fizzled, and luckily for us, it looks like Laura has turned sufficiently that instead of hitting Galveston and Houston, it's more likely to hit closer to Port Arthur and then Baton Rouge. So we are likely to miss even the back end of the storm as it comes inland, which is good and bad. It couldn't hurt us to have the rain, but nice not to have too big a storm and not to have all the potential damage and issues on the Texas Gulf Coast. But it varies. The new plan is if a hurricane is headed toward New Orleans, they will move the court again, but they will move the court to Dallas rather than to Houston. Novel concept. Maybe it makes more sense for the court, if it's moving because of weather patterns, to go more inland than to stay on a coastal or fairly coastal location, which is also subject to the vagaries of the hurricane season. All it takes is experience. So the Fifth Circuit sits in New Orleans unless they've moved for some particular purpose. Finally, at the highest level, we have one U.S. Supreme Court. David, you're probably right. But the benefit of a tornado, one, the records are off-site, and the federal courthouse in Dallas has a very, very large storm shelter. And a tornado is a much briefer occurrence than a hurricane. Each of the different circuits contains multiple districts. As I say, each of the geographic circuits contains 3 or more states or territories. The largest is, I believe, the 9th. Let me look to make sure I'm remembering. Yes, is the 9th Circuit. The 9th Circuit Court of Appeals is most of the Western United States. 9th Circuit is Alaska, Hawaii, Guam, the Mariana Islands, Arizona, California, Nevada, Oregon, Washington, Idaho, and Montana. That's a very, very large geographic circuit. The smallest is the DC Circuit, which is just the District of Columbia. On the state side, we have all of those myriad of trial courts at the bottom. We have 14 intermediate courts of appeals called the Texas Courts of Appeals, which serve geographic districts. Fort Worth is in the 2nd Court of Appeals district. The 2nd Court of Appeals actually sits in the courthouse in downtown Fort Worth, and it serves Tarrant County as well as several of the surrounding counties. Puerto Rico and the Virgin Islands, I have to look. I believe they're in the 11th Circuit, along with Florida, Georgia, and Alabama. So the Pacific Islands are all in the same district with the Pacific Coast states and the states slightly inland from there. The Caribbean islands are in the same circuit as the southeastern states, Florida, Georgia, Alabama. With regard to state courts, there are 14 state courts of appeals. The 1st and 14th districts are in Houston. They have so much work that they actually needed 2 courts of appeals. The 2nd Court of Appeals is in Fort Worth. Third Court of Appeals, I believe, is Travis County in Austin. I know that Dallas is the Fifth Court of Appeals, for maybe San Antonio. It's in your Texas courts booklet. I just don't have that in front of me right now. When a case from Fort Worth goes up on appeal to the Second Court of Appeals and they make a decision, that decision is then binding on all of the courts in Tarrant County and the other counties that are part of the Second Court of Appeals district. If you have a trial in Tarrant County over a subject matter that the Second Court of Appeals has not had a decision on, and there's no decision from the highest courts in Texas, the court in Tarrant County will be able to apply whatever rules of law they choose to apply. What happens if the Second Court of Appeals has been silent, but the Fifth Court of Appeals in Dallas has issued an opinion on this subject? The Fort Worth court can choose to follow what Dallas did. That is, they can be persuaded that what the Fifth Court of Appeals did in Dallas is applicable and apply it. Or if there was a decision from Houston that was different, they could do what Houston did. Or the trial court in Texas can choose to do neither, do something completely different that is based upon their own reasoning in the case. And so it is possible to end up with different rules of law, different parts of the state, each of which is binding solely upon the courts that report to that particular district. Eventually, one or more people involved in those cases is likely to appeal that case or that subject matter to the highest court in the state. In Texas, we have two highest courts. We have chosen to divide the jurisdiction of what would be heard by a Supreme Court along subject matter lines. That is, we have a highest court for civil matters and a highest court for criminal matters. The highest court in Texas for civil matters is the Texas Supreme Court. The highest court in Texas for criminal matters is the Texas Court of Criminal Appeals. These are co-equal courts that don't talk to each other. That is, a case is either civil or criminal. If you don't like what the Court of Criminal Appeals did, you can't take to the Texas Supreme Court. They don't have any jurisdiction, and vice versa. So when you appeal to the highest court, it will go to the court that is applicable for the subject matter of the case. And when that court speaks, then all jurisdictions within the state are required to follow what that highest court did. On the federal side, you can have one decision from the Fifth Circuit Court of Appeals in New Orleans on a given subject and a different opinion from the Ninth Circuit Court of Appeals in San Francisco. And those cases will be binding on the states and territories within their jurisdiction unless and until someone files an appeal with the U.S. Supreme Court, which is accepted, and the Supreme Court makes a ruling, at which point when the U.S. Supreme Court speaks, that creates the law for all jurisdictions, and that becomes the law everywhere. Then all of the courts of appeals have to listen. The key thing to remember is it's hierarchical. When the highest court speaks, everyone listens. If you're looking at a court of appeals opinion, whether or not it is binding, whether it actually sets a particular precedent, will be solely dependent upon whether or not you report to that court. That is, which jurisdiction you are in. I will draw a diagram of how this sort of works. Normally I would put it on the board. I've been having a little trouble using the whiteboard in Blackboard, so I will do a diagram that I will upload to Blackboard so you will have that to work from to give you a visual of how this works. I just haven't gotten it finished yet. There are certain matters over which a state court has exclusive jurisdiction, specifically matters of state law. And there are some matters over which federal courts have exclusive jurisdiction, some areas of federal law. And there are some areas where you can choose your forum. That is, you can file it in state or federal court, depending on the parties and the circumstances. Our doctrine of following precedent in this country, which created our common law theory of justice, is dependent upon three particular Latin terms that you need to be familiar with. Those three terms are stare decisis, ratio decidendi, and dictum. And once you understand what each of these are, it's a little easier to understand how the doctrine of following precedent works. I am putting the three Latin terms in the chat, so you will have those three terms, because I'm going to talk about each of them individually, but sometimes it's hard to know how to spell those Latin words, and so I want to make sure you know clearly what we're dealing with. Starry decisis is a Latin phrase that means to stand on what has been decided. Under the doctrine of stare decisis, the decision of a court is binding authority on the court that issued the decision and on the lower courts within the same jurisdiction for the disposition of factually similar controversies. In other words, once a court makes a decision and issues an opinion that is binding on the courts below, not only is it binding on those lower courts, it is actually also binding authority on the court that issued that opinion, absent an ability to demonstrate that something has changed or that there is some factual distinction on which you can base a different decision. This past end of June, beginning of July, the U.S. Supreme Court issued a number of decisions. One of those decisions pertained to a Louisiana law regarding abortion clinics and the requirement that physicians working in abortion clinics have admitting privileges in a local hospital. The Supreme Court found that the Louisiana statute was unconstitutional, and the plurality opinion was that it was unconstitutional for a variety of reasons. Chief Justice Roberts wrote an opinion that said because the statute was on its face so similar to the Texas statute that was found unconstitutional a couple of years ago, that based on stare decisis, the Supreme Court was required, in his opinion, to uphold what was done in the previous case and to find the law to be unconstitutional because it was so similar to the previous law that had been invalidated that you could not actually distinguish between the two or find some reason for a differing opinion. Recognize that Chief Justice Roberts was on the other side of the Texas case. So he didn't believe that the Texas law was unconstitutional. However, a majority of the court found it to be unconstitutional, and that created a precedent which Chief Justice Roberts believed compelled the Supreme Court to follow what the prior opinion had required, even though he didn't necessarily agree with the argument in it. Because it wasn't a majority opinion of the court, it was to be afforded due deference by the court unless and until there was a mechanism or a factor involved that would allow them to directly distinguish the case in front of them from the previously decided case. And the Louisiana case was so similar as to not create that distinction. This last term of the court, we had a significant demonstration of the exercise of how the Supreme Court functions in terms of determining whether precedents apply and why and how you interpret statutory material, etc. I would recommend reading the most recent decisions of the Supreme Court to get a flavor for how the court handles things. There have been some very, very interesting cases. As we go along, I will mention Supreme Court cases and things, mostly within the last decade or so. I had the privilege of actually being the last person seated in the courtroom the day that Justice Kennedy issued his opinion in the Obergefell case, which was the case where the Supreme Court determined that discriminating in the issuance of marriage licenses on the basis of the genders of the parties requesting a license was unconstitutional, and thus approving gay marriage in the United States throughout the country. It was a very powerful moment. When you're sitting in the Supreme Court and they are issuing an opinion and you realize that with a stroke of a pen and the reading of an opinion, the law in the entire nation is changing because of an interpretation by the court, that's a very, very powerful thing. It was very, very cool to be there. My son was moving to DC, or the DC area, to work for NASA, and so I was in town for about 5 or 6 days while he had meetings, trying to help him find an apartment. But he had meetings in the morning and we were apartment shopping in the afternoon, and so it was the last 3 days of the Supreme Court, and I went down to the court and stood in line to hear opinions delivered, and I was lucky enough to be seated all 3 days. And there were a lot of important cases. There were 7 cases over 3 days issued. I like to watch the court. I think what they do is important, and I think it can make a huge difference in people's lives, and people don't always pay attention to what they're doing. So I do recommend it. My preference is, while I look at the U.S. Supreme Court's own website, that's supremecourt.gov, Bloomberg News has its own website called the SCOTUS blog. SCOTUS is the abbreviation for Supreme Court of the United States. And so scotusblog.com is a really, really nice website. They live blog every day. The decisions are being issued. And so if you know that the court's issuing opinions, you can actually watch the live blog, and they'll tell you what the decisions are and what they mean. And the people who do the blogging are appellate court lawyers who have appeared before the Supreme Court and have significant knowledge and understanding of how the court works and how to read those opinions. Actually, the day that the first Affordable Care Act case was decided, where they found that they upheld the requirements of the Affordable Care Act, not under the Commerce Code and the Commerce Clause of the Constitution, but under the taxing authority of the U.S. government. SCOTUS Blog was the only news organization that actually got what the decision was correct. As they started to read the decision, printed copies of the opinion were distributed to the news media, and Chief Justice Roberts' opinion in that case started out explaining why, under the Commerce Clause, the provisions, the mandatory provisions requiring people to purchase health insurance, which have since been statutorily changed, but were in the original law as passed, were not authorized by the Commerce Clause. And so you got lots and lots of people saying that the universal mandate was held unconstitutional. They didn't read far enough. Yes, it was not constitutional or authorized by the Commerce Clause. However, it was authorized as a tax. Under the taxing power of an authority of the U.S. government, they could require people to pay a penalty or a tax for failure to obtain health insurance. And rather than looking at the words that were used, as the Chief Justice said, if it looks like a duck and it quacks like a duck, it's a duck, even if you call it a penalty. So if it looks like a tax and you report it on your tax return to the Internal Revenue Service, and it's collected by the Internal Revenue Service, which is empowered to collect taxes, the fact that the law called it a penalty and not a tax didn't change the fact that it was, in effect, a tax. And as a tax, the legislature was perfectly authorized to choose the basis on which taxes could be assessed. And so it was constitutional as a tax, even though it was unconstitutional as requiring commerce. Basically, it was unconstitutional under the Commerce Clause because while Congress has the right to regulate commerce, the court ruled that they did not have the right to require commerce. So they could regulate when and how insurance was made available, but they couldn't require people to purchase insurance, that is, to engage in commerce. However, they could penalize people under the taxing authority for not acquiring insurance, which is how the universal mandate became legally authorized. Fast forward half a dozen years or so, and you end up with the legislature, with Congress, repealing the universal mandate and finding that it's no longer mandatory that you purchase health insurance. And so the ruling by the Supreme Court became moot because Congress changed the law. All the court was doing was saying the law that Congress passed was constitutional, it was enforceable, but Congress always has the right to change the law should they choose to do so. So stare decisis is the principle that we follow what previous courts have done. The ratio decidendi is the holding or the principle of law on which a case is decided. The ratio decidendi is the thing that actually sets the precedent, and it's what is binding on courts in the future. Courts in this country do not state general propositions of law, nor do they answer hypothetical questions. They decide actual cases and controversies and announce rules that are tied to specific fact situations. So just because you have a possible precedent, a ratio decidendi, you have to consider that along with the facts of the case itself. Essentially, in this most recent abortion clinic case from Louisiana, Chief Justice Roberts ruled that the prior precedent directly applied because the facts were so similar as to not be able to distinguish between the facts of the two cases, and that they were so similar that the court was bound and required to apply the prior precedent. And there were 4 justices who disagreed with that, but that was the basis of his opinion in that particular case. So sometimes you have differing opinions. How do cases get to the Supreme Court? Well, in this country, there are a few cases where if someone files an appeal, the court has to take it mandatorily, but those are very, very narrow scope. The most of the time, cases are appealed to the Supreme Court through an application for writ of certiorari. That is a request that the court discretionarily choose to hear the case. And 4 justices have to agree to hear the case for it to be put on the calendar. Most of the time, the court will only grant cert, as we call it, grant the application for writ of certiorari, if you have a lower court case where a federal statute has been held unconstitutional, or you have a situation from a lower court where the decision in one court, from one court of appeals, is contrary to a decision of another court of appeals. For years, cases had been appealed to the U.S. Supreme Court on the question of gay marriage, but they never heard any of them. They didn't take any of those cases because until the lower court decision, the Court of Appeals decision of, let me make sure I get the right court. Yeah, the Sixth Circuit in Ohio, holding that the statute requiring that a marriage license could only be issued to one man and one woman was constitutional. All of the previous decisions from other courts of appeals had found that type of law to be unconstitutional. There was no conflict. It was actually sort of a race. There was a case, the Obergefell case in Ohio, and there was a case from Texas being heard by the Fifth Circuit in New Orleans at about the same time. And the Obergefell case upholding the limitations on marriage licenses was decided before the Fifth Circuit issued an opinion. And when Obergefell then appealed their case, filed an application for writ of certiorari to the Supreme Court, it was granted because the application for writ was on the basis that the Sixth Circuit decision was directly contrary to the decision of the Eighth and Ninth Circuits, which had previously ruled differently. As soon as the Supreme Court granted cert in the Obergefell case, the Fifth Circuit issued a stay on the case out of Texas and said, we're not going to rule until the Supreme Court issues an opinion in the case pending before it, because the facts are sufficiently similar. There's no reason for us to take action on this, only to have it change depending upon what the Supreme Court did. So we will hold making any decision in this case until the Supreme Court issues their decision. And when they issued the decision, then the matter was decided, and So the Fifth Circuit did not get to weigh in on whether or not gay marriage should be legal in this part of the country. They deferred action until action was taken by the Supreme Court because the case was pending. The holding or principle of law, the ratio decidendi, in the Obergefell case was that the gender distinction in the marriage license law violated the Equal Protection Clause of the Constitution. And that there was no substantial governmental reason or state reason to impose an arbitrary restriction of this type. There was no compelling state purpose in preventing individuals of the same gender from marrying. With regard to how to pronounce the Latin terms, most of these Latin terms appear in a legal dictionary, and most legal dictionaries include not only the definitions of the terms, but they have pronunciation explanations within those definitions to help you to learn how to pronounce them. Not a stupid question at all. I know most of this both because we did a lot of discussing of Latin terms in law school, and more particularly because from 7th to 10th grade in high school, I took Latin. So I took 4 years of Latin in high school, and so we learned a whole lot about how to pronounce Latin words and how to determine how to pronounce Latin words. Occasionally, you will see that some of the legal terms are pronounced differently than normal Latin would be pronounced, and that generally has more to do with local vernacular, etc. Some legal terms actually come to us from other languages. For example, the term for the jury selection process is in Old French voir dire, but we live in Texas, so everybody says voir dire. And so sometimes you just have to know your local verbiage and pronunciation so you don't stand out as being somebody who isn't from here. So the ratio decidendi is the point of law on which the case turns, and that's important. Finally, sometimes when you have a case that goes up on appeal, it's very rare that you appeal a case alleging only a single error of law on the part of the lower court. You usually file your appeal alleging that the court erred in several different ways. And if the higher court overturns what the lower court did, they generally overturn it based on one of those points of law. Occasionally, a court will say, well, we're deciding this point of law, but you appealed these other 5 things, and oh, by the way, if we'd gotten to these 5 things, this is what we would have done with them. That oh, by the way language is what we call dictum, or obiter dictum. And the information that is considered to be dictum is not binding on other courts, but it can be significantly persuasive. Let me give you an example. We had a trial, and the court made certain decisions. They seated a jury, evidence was presented, and they allowed certain evidence to be admitted in the court, even though the defense objected to the introduction of that evidence, that it was highly prejudicial. That is, it made their client look bad, but it had no real probative value. It didn't actually prove anything. It was presented with the intent to inflame the jury rather than to actually prove their case. But On appeal, they appealed on numerous errors, and as it turned out, one of the errors they appealed on was that the jury was improperly constituted. That it turned out somebody who ended up on the jury shouldn't have been eligible to serve on the jury because they didn't live in the county where the case was being heard. And that happens occasionally. The reality is that county lines often run down the center of a street. And so, for example, over in Grand Prairie, the Dallas-Tarrant County line actually runs down the middle of a north-south street at one point, and all the houses on the east side of the street are in Dallas County, and the houses on the west side of the street are in Tarrant County. But there's a cul-de-sac at the end, and there's a house that's sort of in the middle. And some in the records in Dallas County, it said that all the houses with, and I can't remember if it was even numbers or odd numbers, are in the county, and the ones with the opposite are in Tarrant County. Well, this house broke the odd and even rule. That is, it had an address that sounded like it should be in Dallas County, but it was really in Tarrant County. And somebody living in that house was summoned for jury duty. They were told to come to jury duty, so they went to jury duty, and they didn't pay attention to which county it came from. That person got selected to be on the jury and ended up on the jury of this case. On appeal, they claimed that the jury's decision should not stand because there was a member of the jury who shouldn't have been allowed to serve, who was disqualified from serving because they were not, in fact, a resident of the county where the trial was held. And the Court of Appeals agreed and reversed the case. But they said, oh, and by the way, if we'd gotten to these other points of error where you said the court allowed certain testimony in that should not have been allowed, if we had gotten to that question, we would have overturned the case on that matter also, because the probative value was very minimal and the prejudicial nature overwhelmed whatever probative value might have been there. Now, that wasn't binding, but it was very informative of what the Court of Appeals might have done. And they did that, oh, by the way, language, because the case was going back to the trial court for a new trial, a trial where they select the jury better. But the court wanted to give the judge information so that he didn't make the same mistakes again. So the matters that were previously appealed that didn't get decided, they told the trial judge what they would have done if they had gotten to them. The purpose of which was to ensure that when they had a retrial of the case, they didn't make those same mistakes again. Now, what the Court of Appeals had to say on those other matters was not binding. The trial judge did not have to follow the Court of Appeals directions. They could choose to follow them, or they could choose to not follow them, with the understanding being that yesterday's dictum may be tomorrow's ratio decidendi. So the judge determining what evidence they would or would not allow, in part, had to decide, if the case went back up on appeal, do I want to get overturned again because I didn't listen to what the court told me they were likely to do? And so that becomes its own question. And that is why dictum or obiter dictum is also important when you're looking at cases, because sometimes your fact situation, the situation you're researching, is the question of law that didn't get decided, but might be directly applicable to arguing whether or not the evidence should be allowed in at the trial. Attorneys do know the decisions, and they can revamp their cases on retrial, and they do choose not to present that evidence if the court said that they shouldn't. But sometimes they'll try to present it hoping the trial judge will let it in anyway, and the judges are also familiar with the case and don't let it in when it's an appeal from that individual case. Sometimes you're in front of a judge in a completely new case with a similar set of facts. This is where a portion of the case, which is not binding, may be argued and be highly persuasive to persuade a court what direction to act and what decision to make in applying those particular matters. Courts have leeway in interpreting precedent. It's extremely rare that you get the exact same fact situation presented in court. Very honestly, in his opinion in the Louisiana abortion clinic case, Chief Justice Roberts was fairly scathing about the fact that Louisiana, in direct contravention of the Supreme Court's decision, didn't write the law differently. He was essentially encouraging states to reformat laws or to submit something that wasn't so identical to what had previously been held to be unconstitutional, to give the court the ability to actually look at the question again. But because the new action was so close to the previous situation where the court had ruled, that he felt the court had no alternative but to uphold the prior decision, even though it was a prior decision that he didn't actually agree with when the decision was issued. And so that in itself is an interesting quirk of how it works. Part of the process in making decisions and in applying precedent involves determining whether the precedent applies, whether the difference in the facts prompts a different result. If a court can find sufficient facts to distinguish between the two cases, that difference in the facts can allow them to have a different end result. Courts will often look at which court made the prior decision, whether it was a unanimous decision or what the breakdown was, who wrote the opinion, what have the commentators had to say, what did they have to say about the case. All of those are factors that may go into deciding when or how a particular precedent is applied. It's also important to note that when a case goes up on appeal, there are lots of factors that may be impacted. And if it gets reversed on appeal and sent back, remanded, as we say, for a new trial or further proceedings, how the trial court proceeds in that matter can be significantly dependent on the extent to which the Court of Appeals was explicitly clear on what they needed to do and why. Sometimes evidence comes in that's a surprise. We do not have trial by ambush in this country. That is, if you make a proper request, you're entitled to know who the witnesses are and to have at least some summary of what the testimony is likely to be. Occasionally, a witness will surprise you and say something that wasn't in their report or that is different, and that can create a surprise on the part of the other side, because even the people who are calling that witness for testimony aren't aware of what the person is likely to say. when evidence is presented, it is incumbent upon the other side to object if they find the evidence being presented objectionable. If you don't make an objection, you lose the right to complain about it on appeal. So you make an objection, you have to get the court to rule on that objection. And you need to make oftentimes a series of objections to ensure that you preserve your rights on appeal. Almost a decade ago now, there was a case in Houston where a woman by the name of Andrea Yates drowned her children in the bathtub. Andrea Yates pled not guilty by reason of insanity and was put on trial. She had had a long history of major depression with psychotic features that was exacerbated by pregnancy, and she was homeschooling 5 children under the age of 8. And she killed all 5 of those children. In her first trial, one of the experts called by the prosecution on rebuttal was a psychiatrist from California who, unknown to either side, this was going to be part of his testimony, testified that he had consulted on a script for Law and Order. And in that script, a woman killed her children and claimed that she was not guilty by reason of insanity as a result of postpartum depression. And that he had been told that Andrea Yates was an avid fan of Law and Order, that she watched all the different versions of Law and Order and Law and Order SVU, and in those days there was several other versions of Law and Order. She watched all of them. And so his assumption was that she watched this episode of Law and Order and she copycatted the TV show in what she did. And so he didn't believe that her actions were as a result of any mental illness, excuse me, but that they were as a result of having watched this show. Well, nobody heard anything about this Law and Order thing till he said it at trial. The judge gave the defense over the weekend to do some research, which they didn't get a lot of stuff done, and ultimately the case was rested before they were able to get a hold of someone from Dick Wolf's company to find out about the show. I know it's time. Ultimately, it turned out that after the script was approved, it was never filmed. Since it was never filmed, it was never aired. Since it was never aired, she could not have watched it. At the trial, they didn't know that until the jury was deliberating, and the defense asked for a mistrial, which was denied, and then they asked for a curative instruction, which was also denied. On appeal, the Court of Appeals overturned it, not because it was perjured testimony, not because he lied, he was just misinformed, but because once the truth was known, the court didn't actively take steps to correct the mistaken opinion in the minds of the jury. So how they determine what they determine can be based on a lot of different types of facts. I will leave you with that today. The reading for next time is to continue reading chapter 1, and we will continue to walk through chapter 1 next week. Have a great weekend. I will see you on Monday. With regard to parallel courts at the different level, it really depends upon the jurisdiction. They don't always have jurisdiction over the same things. They're just at the same level. We'll actually discuss that in detail when we discuss Texas courts in the intro class. And so I will defer that to that part of the Introduction to Law course. Everybody have a great weekend, and I will talk with you soon.